My name is Soren, and I was 34 years old the afternoon a man I had never met changed the locks on the house I had lived in for 6 years and left a handwritten note on the front door that said, "The property has been transferred. Please collect your belongings by Friday." That was how I found out. Not from my ex-husband. Not from his attorney. A note on a door, in handwriting I didn't recognize, with a Friday deadline and no return contact. My ex-husband's mother called that evening. She said, "I think it's cleaner this way, don't you? You were never really on the deed. The house was always in the family." She said it the way you say something you've been rehearsing, smooth and finished, no rough edges. I said I understood. I hung up. I sat in my car in the parking lot of the Walgreens 2 blocks from the house, and I looked at my phone for a while, without doing anything with it. What Patrice, that was her name, my ex-mother-in-law, didn't know was that there was a document she hadn't looked for. Something recorded at the county office 7 years earlier, before the marriage had started unraveling, back when I had still believed in the architecture of what we were building together. Something that nobody had thought to check when they were drawing up the transfer. I found out they hadn't checked it 6 weeks later, when the recorder's office called my cell phone on a Thursday morning and a woman named Beverly said 4 words that changed the shape of everything. I want to tell you what she said. Welcome back to channel, where quiet people let the county recorder do the talking. If this is your first time here, subscribe. New stories every week and you will not want to miss what's next. Drop a comment. Has anyone ever tried to take something from you by counting on the fact that you wouldn't look? Section 4, Full Body. Block 1. Backstory/quiet confidence/anchor elder. I grew up understanding that the difference between having something and keeping it was documentation. My grandmother taught me that. Her name was Augustina. Everyone called her Gussie, and she had come to this country from the Philippines at 22 with 1 suitcase and a folder of papers she kept in a fireproof box under her bed for the rest of her life. Citizenship certificate. Work permits. The deed to the house she bought in Stockton, California in 1974, which she paid off in 11 years on a seamstress's wages and which she referred to, without drama or sentiment, as her proof. Paper is proof, she used to say. Not as a lesson, just as a fact, the way you state facts that seem obvious to you because you learned them the hard way. Anybody can say anything. Paper is proof. I grew up in that house in Stockton, the second of 3 grandchildren Gussie raised after my mother moved to Sacramento when I was 4, and my aunt took the other 2 kids, and my uncle went somewhere nobody tracked. Gussie did not complain about this arrangement. She enrolled us in school, attended every conference, made rice every night in the same pot she'd brought from Manila, and kept the fireproof box under her bed with the same consistency she kept everything else. When I was 12, she showed me what was in it. Not as a ceremony. She needed something from the bottom of the box and asked me to help her sort through the top layer, and as we went through the papers she named each one and explained what it proved. Date. Title insurance policy. Water rights filing. The documentation for the solar panels she'd had installed in 1991. A copy of her will, which she had updated the previous spring with an attorney in the strip mall on Pershing. "This box is the house," she said. "Not the walls. This." I kept that. I kept it the way you keep things that don't feel important until suddenly they are completely essential. I was not a particularly studious child, but I was a careful one. I noticed things and I kept track of them, and I had a natural instinct for the kind of order that prevents problems before they happen. When I went to college at Cal State Sacramento, the first in Gussie's household to go, I studied business administration with a focus on operations, which sounds dry and is in fact extremely practical, the art of knowing where everything is and what it's connected to. I graduated at 22, got a job at a regional property management company in Sacramento, and spent 4 years learning how rental portfolios work from the inside, how leases are structured, how titles are held, how the paperwork that looks like administrative tedium is actually the skeleton that holds the whole thing upright. I was 26 when I met Thaddeus. He was 30, worked in commercial lending, had the easy confidence of someone who had never had to be careful in the specific way that Gussie had been careful. He was warm and funny, and he called when he said he would, and he liked Gussie immediately, which counted for something. We dated for 2 years. We got engaged. We bought a house in Elk Grove, a 3-bedroom on a quiet street, 30-year mortgage, 30% down, which was a stretch but manageable if we were both working, which we were. The house purchase was where I first noticed something I filed away and didn't examine directly for several more years. When we sat down with the escrow officer to sign the closing documents, Thaddeus's mother, Patrice, was present. She had driven up from Fresno for the occasion, and she sat at the corner of the conference table with the quiet authority of someone who considers herself a participant in proceedings she has not been formally invited to join. She asked questions throughout about the loan structure, the title insurance, the HOA documents, and the escrow officer answered them with a slightly strained professionalism of someone managing an unexpected additional party. At one point, when we reached the deed of trust, Patrice leaned forward and said to the escrow officer, very pleasantly, "The title, it's in both names?" The escrow officer confirmed that yes, both Thaddeus and I were named on the deed as joint tenants with right of survivorship. Patrice said, "Of course," and sat back and didn't say anything else about it. I noted the question. I noted the slight pause before she said, "Of course." I filed both observations in the part of my mind where I put things I wasn't ready to think about yet and went back to signing the 47 pages that constitute a residential real estate closing. We moved in that September. We got married the following spring, a small ceremony, 20 people, the backyard of the Elk Grove house with strings of lights in the oak tree. Gussie sat in the front row in a blue dress she had made herself and cried in the quiet, internal way she did everything. Patrice sat 3 chairs down and wore a cream suit that I thought was a deliberate statement about something, and then decided I was being uncharitable. The first 3 years of the marriage were good in the ordinary, functional way that good marriages are, not dramatic, not particularly eventful, just the accumulation of shared routines and small decisions, and the gradual project of making a life that fits 2 people. Thaddeus was a good partner in the practical sense. He paid his share of the mortgage consistently, showed up for the maintenance tasks, made dinner 2 nights a week. He was less available in the less practical sense, the conversations that required him to be fully present, the ones that needed his attention rather than his competence. He was good at the logistics of a marriage and less practiced at the interiority of one. Gussie died when I was 29. She died in the Stockton house, in her bedroom, surrounded by the 3 of us who had grown up there. She had been in declining health for a year, nothing dramatic, just the slow subtraction of age, and her death was, by the standards of death, a gentle one. She left the Stockton house to me and my 2 cousins in equal thirds, which I managed with an attorney in Stockton over the following months, and she left me the fireproof box. I drove back to Elk Grove with the box in the passenger seat and put it in my own filing cabinet, under the bed the way she had kept hers, and inside it I put my own copies of every property document related to the Elk Grove house, the deed, the title insurance policy, the HOA bylaws, the mortgage statements, the survey from the original purchase. Gussie's habit carried forward. There was one additional document in the Elk Grove file that I had not shown Thaddeus, not because I was concealing it, but because it hadn't come up and the moment to mention it had never presented itself with any particular urgency. It was a recorded instrument I had filed at the Sacramento County Recorder's Office. No, Elk Grove falls under Sacramento County. 2 years into the marriage, when I had handled a similar transaction for a client at the property management company and recognized that our own deed, while correctly structured at purchase, could benefit from an additional recorded instrument clarifying the survivorship provisions in a way that was slightly more explicit than the standard joint tenancy language. I had filed it myself, professionally, the way you file a routine instrument when you know how. Paid the recording fee. Received the stamped copy. Put it in the fireproof box. The instrument was a recorded affidavit of title interest, a document that, in plain language, stated clearly and on the public record that Soren Biani Mercado held a fee interest in the property at the subject address, recorded independently of the deed of trust, with a legal description that matched the parcel exactly, and a recording date of February 2017. I knew what it was. Gussie would have known what it was. What I did not know in those years was how important it would become. Block 2. The betrayal in full. The marriage began to come apart in the 5th year, the way some things come apart, not in a single event but in a gradual loosening of the connections that had been holding it together, so gradual that you can't identify the moment it became irreversible, only look back later and find the point where the direction changed. Thaddeus had a work friendship that became something else. I am not going to give it more weight than it deserves in this story. It was painful and it was real, and it changed the architecture of what we were, but it is not the center of what I want to tell you. The center is what his family did with the paperwork. We separated in the early fall of my 33rd year. Thaddeus moved out. I stayed in the house. We engaged attorneys. Mine was a family law attorney in Sacramento named Deirdre, who had the efficient, unsentimental manner of someone who has guided many people through the mechanics of ending a marriage and understands that efficiency is a form of mercy. Thaddeus's attorney was a man named Paul, who had an office in Roseville and who communicated exclusively through formal letters that arrived by courier even when an email would have served perfectly well. The divorce proceedings took 11 months. They were not acrimonious by the standards of these things, no children, no business assets to divide, the primary dispute being the house. The mortgage was jointly held. The deed named both of us. The question was straightforward in legal terms. The house would be sold and the equity divided, or one party would buy out the other's interest. What Thaddeus wanted, it emerged through Paul's courier letters, was to keep the house. He proposed buying out my interest at a valuation that Deirdre flagged as approximately 18% below the current market. I declined. We went back and forth for several months on the number. The market valuation question went to an independent appraiser. The appraiser came in at a figure that was, to my mild satisfaction, 12% higher than Thaddeus's original proposal. Throughout this process, Patrice called Thaddeus regularly. I knew this because Thaddeus mentioned it in the occasional conversations we still had about logistics, with a slightly burdened tone of a man whose mother has opinions he is obligated to process. What Patrice's opinions were, specifically, I did not know in full until after. The divorce finalized on a Wednesday in March. I was in Deirdre's office when the paperwork came through. Deirdre shook my hand. I drove home to the Elk Grove house, which was still nominally mine for the transition period, Thaddeus having agreed to a 60-day post-finalization window before the formal sale process began. I arrived home to a locksmith's van in the driveway. The man with the locksmith's van was pleasant and professional and completely indifferent to my situation. He had a work order, he said. He'd been hired to rekey the locks. He showed me the work order on his phone. The client name was Hargrove Property Management, LLC. I stood on my own front porch and looked at the work order on a locksmith's phone and felt the specific sensation of understanding something and not yet knowing all of what it means. I said, "Who authorized this?" He said, politely, that the work order had come through the LLC and he didn't have additional information beyond the address and the task. He was very sorry if there had been a miscommunication. There had not been a miscommunication. There had been a plan. I called Deirdre from the driveway. She did not answer. It was evening. I called Thaddeus. He answered on the fourth ring, and there was something in his voice when he heard me that was not quite guilt and not quite defensiveness but had properties of both. "The house," I said. "What did you do?" A pause. "My parents set up an LLC," he said. I signed a quitclaim deed last week. Before the finalization. My name off, the LLC on. My parents' attorney said it was a clean way to handle the transition. "Thaddeus," I said. "The house was in both our names. You can't quitclaim your interest without addressing mine." My parents' attorney said that since the divorce was finalizing. "That's not how property law works," I said. Another pause. "My mom thinks it's better this way. She said the house was always going to stay in the family, and it's simpler if it's in the LLC now, and you'll get what you're owed through the equalization payment." "What equalization payment?" He named a figure. It was 31% below the appraised value. I stood in my driveway in the March evening, the air cold and smelling of rain, looking at the house I had lived in for 6 years, and I thought about the fireproof box under my bed. I thought about the affidavit of title interest. I thought about the recording date, February 2017, and the legal description, and the Sacramento County Recorder's stamp on the certified copy. I said, "I'll need to speak with Deirdre." He said, "My mom really just wants this to be clean." "I understand," I said. I hung up. The note appeared on the front door the following morning. Patrice called that evening. Her voice had the warmth and finish of someone delivering an explanation they have practiced. The house had always been in the family. I had never really been on the deed in any meaningful way, and wasn't this just cleaner than a drawn-out sale process? She said cleaner, the way people say a word when they mean several things by it, and hope you'll absorb the secondary meanings without requiring her to say them. I said, I understand your perspective. She said, I'm glad. I always liked you, Soren, you know that. I said, I know. I hung up and sat in my car in the Walgreens parking lot and looked at my phone and thought very carefully about what I was going to do. What I was going to do was call Deirdre in the morning, retrieve the certified copy of the affidavit from the fireproof box, and let the documentation do what documentation is designed to do. I packed one bag that night, essentials, laptop, the fireproof box, and went to stay with my cousin Marisol in Sacramento. I did not call Patrice back. I did not contact Thaddeus again except through Deirdre. Deirdre, when I reached her the next morning and explained the quitclaim situation, was quiet for a moment. Then she said, they filed a quitclaim on his interest only? That's what he said. And there's an existing recorded instrument in your name independently? Filed February 2017. Sacramento County Recorder. She was quiet again. I could hear her writing something. Soren, she said, I need you to send me a copy of that instrument. I photographed it and sent it within the hour. She called back 40 minutes later. Okay, she said. Here's where things stand. What she explained, in the efficient, merciful way she explained things, was this. The quitclaim Thaddeus had signed conveyed only his interest in the property. It could not affect my interest, which existed independently, recorded separately, prior to the quitclaim by 7 years. The LLC had received whatever interest Thaddeus had to convey, which, given the recorded affidavit, was a partial and encumbered interest at best, not fee simple title. The LLC did not own the house. Thaddeus's parents did not own the house. The title to the property was, at minimum, clouded and likely worse than clouded, depending on what Hargrove Property Management LLC's own title search had or hadn't found. Did they pull a title report before filing the quitclaim? I said. That, Deirdre said, is an excellent question. The answer, it turned out, was that they had pulled a title search through a cut-rate online service that indexed the primary deed of trust, but did not capture all recorded instruments in the chain. The affidavit of title interest, which was indexed under a slightly different document classification than the deed itself, had not appeared in their search results. They had moved on the house without knowing it was there. Deirdre contacted Paul, Thaddeus's attorney, formally, in writing, notifying him of the existing recorded instrument and the legal effect on the quitclaim transaction. Paul, to his credit, responded within 2 days. His response had a different quality than the previous courier letters, more careful, less definitive. He asked for time to consult with his client and the LLC's attorney. Meanwhile, the recorder's office, which had been processing the quitclaim filing and conducting a routine chain of title review as part of their indexing procedure, had found the affidavit. A woman in the recorder's office named Beverly called my cell phone on a Thursday morning, 6 weeks after the divorce finalized, while I was eating breakfast at Marisol's kitchen table. Ms. Mercado, she said. Yes. This is Beverly at the Sacramento County Recorder's office. I'm calling regarding a recently filed instrument on a property at. She read the Elk Grove address. We're conducting a routine chain review, and we've identified a previously recorded instrument that appears to conflict with the recent transfer filing. Your name appears on a recorded affidavit of title interest dated February 2017. Were you aware of this instrument? Yes, I said. I filed it. A brief pause. I see. We're going to need to flag this transaction for review. The recorder's office may be issuing a notice to all parties of record. I wanted to make sure you were aware. Thank you, Beverly, I said. I appreciate you calling. Of course, she said. You may want to have an attorney review the situation. I have one, I said. I set the phone down and finished my breakfast. Marisol looked at me from across the table. Good news, she said. The recorder's office found the affidavit, I said. She didn't fully understand what that meant, and I didn't explain all of it. But she understood enough, from my tone and from 6 weeks of watching me manage the aftermath of a situation that had been designed to leave me with nothing, to recognize that something had shifted. "Good," she said, and refilled my coffee. Deirdre called an hour later. The recorder's office had issued a formal title conflict notice to all parties, me, Thaddeus, the LLC, and their respective attorneys. A resolution meeting was required before the transfer could be processed. All parties were to appear, with counsel, at the title company that had been engaged to handle the eventual sale, a firm in Elk Grove whose senior title officer was a woman named Constance, who had been doing this work for 28 years and who, Deirdre told me, was known for running a tight proceeding. I drove back to Elk Grove for the meeting with a fireproof box in my passenger seat, the certified copy of the affidavit in a manila folder on top. Block 3, arrival at the public event / the freeze feet. The title company occupied a suite in a low professional building off Elk Grove Boulevard, the kind of office park that houses dentists and insurance adjusters and the quiet machinery of transactions. The lobby had the particular temperature of buildings that run the AC year-round regardless of the outside weather. The conference room was on the second floor, rectangular table, 8 chairs, a window overlooking the parking lot. Constance was already in the room when I arrived with Deirdre. She was in her late 50s, compact and precise, with reading glasses on a beaded chain and the manner of someone who has seen every variety of property dispute and has stopped being surprised by any of them. She shook my hand and Deirdre's and directed us to the far side of the table. Thaddeus arrived 5 minutes later with Paul. I had not seen Thaddeus in 6 weeks. He had the look of someone who had not been sleeping well. Not dramatic, just a slight drawing in around the eyes that I recognized from the late-stage years of the marriage. He sat across from me and looked at the table. Paul sat beside him and opened a leather portfolio and did not look at me. Patrice arrived last, with a man I had never seen, their LLC's attorney, I assumed, a heavy-set man in his 60s who carried a briefcase that looked like it had been purchased to convey authority. His name, Constance's assistant told us as he sat down, was Mr. Ferris. Patrice looked at me when she came in. Her expression had the careful neutrality of someone managing a situation that had not gone according to plan. She sat down at the near end of the table, between Thaddeus and Mr. Ferris, and folded her hands. 8 people in the room. Constance at the head, her assistant beside her, Deirdre and I on one side, Thaddeus and Paul on the other, Patrice and Mr. Ferris at the near end. Constance opened without preamble. She explained the reason for the meeting. The recorder's office had flagged a conflict in the chain of title for the subject property, specifically a recorded affidavit of title interest that predated the recent quitclaim filing and had not been identified in the title search conducted prior to the transfer. She was going to review the instrument and its legal effect, and all parties were going to need to understand the implications before any further transfer action could proceed. Mr. Ferris said, "We'd like to understand the basis for the recorder's concern. Our title search." "I'll address that in a moment," Constance said, without looking up from her file. She had the quality of a woman who has learned that the fastest way to run a meeting is to control its sequence. She pulled out 2 sets of documents, copies for each side of the table, and slid them across. The affidavit of title interest, certified, with the recorder's stamp and the 2017 filing date clearly visible on the header. "This instrument," Constance said, "was recorded at Sacramento County on February 14, 2017. It is an affidavit of title interest executed by Soren Bayani Mercado, the current legal name of Ms. Mercado here, naming the subject property at its full legal description. The instrument was properly indexed, properly recorded, and has remained in good standing with no subsequent instruments affecting it." Mr. Ferris was reading his copy. His reading had the quality of someone who has found something he did not expect and is managing his reaction professionally. Paul was also reading. The quality of his reading was different, more resigned, with the slight stillness of someone confirming what he had already been told to expect. Patrice was looking at the document. Her hands, which had been folded on the table, loosened. "The legal effect," Constance continued, "is as follows. The quitclaim deed executed by Thaddeus Hargrove conveyed his interest in the subject property to Hargrove Property Management, LLC. It could not and did not affect Ms. Mercado's interest, which was established independently by this recorded instrument. The LLC therefore received an encumbered interest at best. Fee simple title to the subject property is not held by the LLC. She set the document summary down and looked at the room. To be direct, she said, the house was not fully Mr. Hargrove's to convey. The transfer, as recorded, is defective. The room held itself very still for a moment. Mr. Ferris said, "We'll need to contest the validity of the affidavit. The timing of the filing. The instrument was recorded in 2017, Constance said. 7 years before your transfer. There is no basis to contest the recording date. The recorder's office has the original index entry." Thaddeus was looking at the table. He had not looked up since Constance started reading. Patrice's chin moved. Just slightly, a small adjustment, the kind the jaw makes when the words that were ready to be spoken have been displaced by different ones. Paul looked at his copy of the affidavit. Then he looked at Mr. Ferris. Something passed between them that did not require words, the specific communication of two attorneys who have simultaneously understood the extent of a problem. Constance looked at me. "Ms. Mercado, your recorded interest in the property is valid and in good standing. The recorder's office has placed a hold on processing the transfer until the title conflict is resolved. At this point, the decision about how to proceed rests with you." I looked at the affidavit in front of me. The recorder's stamp. The February date. My name in the legal description, exactly as I had written it 7 years ago on a routine afternoon at the property management company, doing for myself what I had done for clients 100 times. I said, "I'd like the house to go to market. Fair appraisal. Net proceeds divided per the divorce decree, with my recorded interest properly accounted for." Deirdre did not look surprised. She had known this was what I intended. Paul said, carefully, "The LLC's position." "The LLC's position," Deirdre said, with the precise neutrality of a very good family law attorney, "is that it received a defective transfer. I imagine they'll want to unwind that before it becomes a larger problem." Mr. Ferris looked at Patrice. Patrice looked at the affidavit on the table in front of her. Her expression had arrived somewhere I had not seen it before, past the careful neutrality, past the managed warmth, at something more unguarded. Something that recognized, I thought, the shape of what had been there the whole time without her knowing. Thaddeus looked up. He looked at me across the table for the first time since he had come in. I held his gaze steadily, and I did not say anything, because there was nothing left that needed to be said in this room. The document had said it. 7 years ago, on a February afternoon, before any of this had happened, I had said it. Block 4, reveal plus validation / cascade / pleading reversal / close. Constance called a brief recess. The room sorted itself the way rooms do after something has shifted, Thaddeus and Paul to the hallway, Patrice and Mr. Ferris to the other end of the conference room with lowered voices, Constance reviewing her file with the equanimity of someone who has watched this exact pattern before. Deirdre and I stayed at the table. She was writing notes in a precise, compact hand. I looked out the window at the parking lot. Patrice's car, a gray sedan, was visible near the entrance. I looked at it for a moment, and then looked at something else. The recess lasted 20 minutes. When everyone came back, Mr. Ferris had the manner of a man who has done a rapid recalculation. He said the LLC would be willing to agree to unwind the quitclaim transfer, provided the parties could agree on a sale process and a proceeds allocation. He said this in the measured, cost-managing tone of someone who is already thinking about the errors and omissions exposure from the title search failure. Paul said his client was prepared to cooperate with a market sale. Constance confirmed that a clean title would require the quitclaim to be formally rescinded before any new transfer could proceed. She named the steps. She gave a timeline. She made it clear that the recorder's office would need to see the rescission before lifting the hold. It took 3 weeks to unwind the quitclaim. Mr. Ferris's firm handled the filing. There was a separate matter involving their title search vendor that I was not a party to, and that Deirdre said I did not need to concern myself with. The house went on the market in May. It sold in 18 days to a young couple with a toddler and a second child on the way, who stood in the backyard on the day of the accepted offer and looked at the oak tree the way people look at something they can already imagine their children climbing. The net proceeds, divided per Deirdre's carefully worded allocation agreement, came to a number that was significantly higher than the figure Thaddeus's family had offered me the week the divorce finalized. It was a real number, in the range Deirdre had projected from the appraisal, and it went into my account on a Thursday morning in June, 11 months after the marriage ended and 6 months after the locksmith's van had been in my driveway. I took Marisol to dinner that night. Nothing elaborate, a Vietnamese place near her apartment that we had been going to since we were teenagers, the kind of restaurant that doesn't take reservations and always has a wait and is entirely worth it. We ordered too much food and split a carafe of iced tea, and I told her the whole story in order, which I had not done before, and she listened without interrupting, which is one of the things I have always valued about her. When I finished, she said, "Gussie would be pleased." "I know," I said. "The box under the bed," she said. "The box under the bed," I said. She raised her iced tea. We clicked glasses. That was it. Patrice called me once, in late April, about 3 weeks before the closing. I let it go to voicemail. Her message was 2 minutes long. She said that she hoped I understood that the family had acted in good faith and had not intended to cause harm. She said that she and Leonard, Thaddeus's father, who had not appeared at any of the proceedings but whose name was on the LLC, wanted me to know they bore me no ill will. She said she hoped I was doing well. I listened to the voicemail twice. The second time I noticed that she never said the word sorry. Not once in 2 minutes. She said good faith 3 times and no ill will twice and understand once. She did not say sorry. I did not call back. I had Deirdre send a brief written acknowledgement that my attorney had received the communication. Thaddeus called 2 weeks after the closing. He was awkward on the phone in the way he had always been awkward when he had something to say that he hadn't found the right shape for yet. He said the sale had gone smoothly. I said yes it had. He said he thought I had handled everything fairly. I said I appreciated that. He said he was sorry about and then he paused for a long time before saying the word situation, which I understood was the word he had chosen because it covered multiple things at once without requiring him to be specific about any of them. I said, "I know." He said he hoped I was doing okay. I said I was doing fine, which was true. That was the last time we spoke. I drove back to Stockton the weekend after the closing to spend a few days in Gussie's house. My cousins and I still owned it in thirds, and we took turns staying there, keeping it maintained. Not yet ready to sell. I slept in the room I had grown up in the bed that had replaced the one I'd slept in as a child, with the window open to the backyard smell of dry grass and evening air. On the second morning, I went through the house and opened the drawers in the rooms where Gussie had kept things, not looking for anything specific, just being in contact with the order she had built and maintained for 50 years. The kitchen drawers with their labeled sections. The linen closet organized by household function. The hall closet with the document files she had never once let go disorganized. The fireproof box was still under her bed. I hadn't moved it. I sat on the floor and opened it and looked at what was in it. Her citizenship certificate, the original deed, the solar panel documentation, the will copy. The things she had brought across an ocean in a folder and kept for the rest of her life. I took out the deed. I read the legal description. The lot number, the parcel dimensions, the names of the original grantors from 1974. I thought about what it had represented to her. Not wealth, exactly, not status. Proof. Evidence of the fact that she had arrived and built something and it was hers, and the record said so. I put the deed back. I closed the box. I thought about my own box, now sitting in the spare bedroom at Marisol's apartment, with the affidavit of title interest in its manila folder, the instrument I had filed in February 2017 on a routine afternoon, without drama, without announcement, because it was the right thing to do, and because I had been raised by a woman who understood what paper is for. Gussie never told me that the box would matter. She just showed me how to keep one. My grandmother used to say, "Anybody can say anything. Paper is proof." She meant it as a practical observation, not a philosophy, but I have come to think it is both. The paperwork you keep, the instruments you file, The things you record at the county office on an unremarkable Thursday afternoon, those are not just administrative tasks. They are the record of what is true, sitting quietly in the public index, waiting for the moment someone decides to look. That's my story. A fireproof box, a February filing date, and a county recorder named Beverly. When you found out what had been done, the locks changed, the transfer filed, the lowball number on the table, would you have let it go for the sake of keeping things clean, or would you have pulled the paperwork? Drop your answer in the comments. Drop a comment, hit subscribe, and I'll see you in the next one.